admitted.
Thank you. And if we may publish it.
Absolutely.
Okay, so this is a photo of my Yukon that, again, was taken by the police at the garage. If you will note, my Yukon doesn't have worn paint around the windshield like the killer's does. I'd like to note that I am in jail. I don't have access to Photoshop. To Photoshop this photo so that to remove any alleged paint, worn paint. I don't also have Photoshop to modify the picture that Mr. Mogg took that shows allegedly that there was worn paint on my car. I'll also note for you, just because, you know, the way that courts work and building records, that the doors on my car do lock and unlock. They do open. They do work. If someone were to open my car door, the visor, it works. It flips up, it flips down. So at any point, at any time, anyone could have opened the car door, flipped up my visor, flipped it down, even just prior to Mr. Mogg taking his photos. And so that's what I've got for that photo. Thank you very much. The cameras that are on the corner of my house, I did install those on September 5th, after my wife and I heard what we thought was a gunshot in the neighborhood. If, you know, and I think that it'd be pretty easy to, you know, well, I know that I said that to Detective Gaddis in my interview, and also it was previously discussed that those cameras were not there during the surveillance on the 1st. So Mr. Mogg would not have found videos for the 2nd, for the 3rd, for the 4th. Personally, I believe that when there's no videos for all those days, I'm not sure how it could be so. No problem.
Regarding your observations.
Of course, Your Honor. Like that, sir? Is that okay? Okay, thank you. And so, I believe both, well, I can't tell you what other people testified to, but I will say that that day, on September 2nd, at 8:50 a.m., I did make a text message from my house. And I did not leave my house. And I'm just going to hit this one point really quickly. Through 9:10 a.m. at the very earliest. Okay. As I testify later, it was much later that I left my home, but again, that's, I believe, an important point. So 8:50 sent a text message, 9:10 I was still home. Now, I would like to share, if I may, R2, I believe, I'm not sure if that's been admitted by stipulation or not. These are the tweets that I made that had any reference to Mr. Gurman.
It's not yet been admitted.
It's marked as
R2.
Yeah, the state had produced a Twitter file that was not in, you know, your typical web browser format. And so when we went to review this, this is how those tweets came up.
any objection?
No objection.
It's admitted, and you may publish.
Here, let's. So you'll notice that you heard about that tweet where I talked about where I joked about hearing rustling in the trash, you know, just a dig at Mr. Gurman, and that was the one that's listed on 6, I believe that's 6:18 at about 7 at almost 8 in the morning. You don't see the other tweets because, again, for whatever reason, they didn't, when they produced this document, they didn't produce replies embedded in it. So, but that's the same one. And you see that my last tweet regarding Mr. Gurman is on 6/19. And there I say, at @JGurmanRJ, at Review Journal. Actually, it wasn't lashing out so much as making sure that you finish the story about the website and maybe poking a little fun. A winky face emoji. You know, I had created, and you'll see that, as has already been admitted, I created this portion of my campaign website that talked about the stuff that, that was different things that I disputed. And so I wanted to draw attention to that. So that's why I goaded Mr. Gurman into that a little bit. At the same time, it was actually June 16th, I had sent a text message to a friend who had reached out to me about, because he was, he just wanted to check in on me. And on the 16th, I conveyed to him that it's all good. I'm not actually mad at it. At this point, I was over it. I'm happy to move on. And I said, although, Gurman says he's going to do a third article, one about the website. I don't give a damn. LOL. I don't know if that's something that we can, thank you, sir, that we can admit, this text message. If we may, or if you could present it for admission.
This is a, he wishes to offer. Absolutely. Make this as a yes. This is going to be J3. Absolutely. No objection.
There being no objection, it's admitted and
Thank
being published.
So you can see the content of there again. 3 days before I sent that last tweet. So again, there were never any messages where I would threaten Mr. Gurman. I'm certain that if there were, they would have been produced. Thank you, sir. The way that I handle things is I figure out ways to do things legally. And I'll discuss that in a little bit as to what I was planning. Your Honor, may I just stand up for one moment to show the jury why I didn't wear name brand shoes at the office? Just for a moment, and
You just want to stand up?
right where I'm at.
Yes.
Okay. So, I don't know if you notice the height difference. I wear lifts in my shoes. I'm about 6'5.5", and I call it a vanity thing, right? I just wanted to feel a little taller. And so, if I may just demonstrate why this is important. So, these shoes that have built-in lifts, they're designed in a certain way where they don't slip off a person's foot when you're wearing them. Right? You can see how this is so elongated because there's a lift in here. Right? So you can't put. It's not, from when I've tried, I could not put a lift in a name brand shoe because that shoe would slip right off. There's not enough of the back of this, once that lift's in there, in order to grab a hold of your foot. So essentially, I'd be kicking my shoes off every time I walk. So, I never wore again, any type of name brand shoe at the office, and I think that that's something that will likely be discussed at closing, and how that's relevant